Imagine you have got a training program, but nothing in the world is so-called original, because somehow you learn from someone and someone learns from someone. So the question is, to what extent can you use other people's idea? So you may ask your lawyer, depends on which country you are watching this video, depends on where you are from, and I'm going to speak about the Commonwealth system, because the Commonwealth system is a system that I'm familiar, and I would like to talk about how you can avoid being sued by other training providers, because the last thing you want is being sued. And if you're sued by the Americans, okay, no offense to the Americans here, but you know your country just loved to sue. It's famous in the whole world. So how do you avoid yourself being sued by the Americans? Because they will be the first one to sue you. All right. So I want to talk about this in this video, and I will not talk about a lot on the legal side, because most of you would, because of the different country system, legal system, you want to, after all, consult your lawyers or legal advisors or attorneys. All right, so I'll just give you some ideas. Okay, so before I do that, I need to ask you for a favor. Would you be willing to do it for me? That is, if you haven't subscribed to my channel, okay, all I need you to do is to help me click the subscribe button, simply because that you help my videos to be reached out to more people. Would you be willing to do it for me? So thank you for that. And also, the bell is there, so hit the bell and get notified of the next video that is going to be uploaded on the channel. Okay? So thank you for doing me a favor. Now, coming back to this topic called the legal issues that you may see. Now, I remember many years ago, I was in the accounting profession, and there was a time when we talk about teaching stuff to other people. So there are a few things that need to remember in terms of the source of information. Number one, the information can be from your clients. So if you're a consultant, but now you're also teaching, so bear in mind that there's a limitation of using your client's information, because when you are engaged by your client, it is under the professional duty to keep the information to be private and confidential. So you can't say that, wow, I actually helped Jack Wong, who is a director of Singapore company back in August 2008. You cannot mention the name of the person for sure. That's stupid, right? It's common sense. But I reckon that common sense is not common. At the same time, you can't mention the name of the company. So the two things that you have to avoid at all costs is to mention the name of the person that you speak with or work with, and also the name of the company. You can talk about a Singapore company. I have a chance of point in August 2008. I was working with this client, and he is the director of a Singapore company. So if you make it generic, where people have no chance to figure out who you are actually talking about, then that's okay. So that's one way to avoid this. But Jack, can you actually avoid telling all these stories? The answer is I can't. Because in order to showcase what I teach in this presentation is relevant and is working, I've got to bring out some of my experiences working with other clients. So in my context as a consultant teaching other people, I've got to actually showcase a number of case studies. So the technique is the art, the science of showing case studies by not mentioning the name of the company or the person or people, the groups of people you're dealing with, and make it as generic as possible. Got it? So I was even engaged in a very scenario, not my case, but I was actually talking about one case, which is a public news. There was a goods and services tax audit many years ago, where a company in Singapore was actually penalized by the Singapore Tax Authority. And how the Singapore Tax Authority discovered the case was they went to this one and only one ticketing company in Singapore. So a lot of people in Singapore, if you know what I'm saying, is cystic. There's only one ticketing company in Singapore. But even to that, I can't mention the name of the company during the training. I would rather say that there's a ticketing company in Singapore. So you see, I make it generic as possible. Well, the answer is that, of course, I also have checked that this piece of information has already been published in Singapore Tax Authority's website, so it's no longer a private, it's no longer private. So yes, when I see that it's public, yes, I can mention, but I want to maintain my professional integrity. All I say is that instead of saying Sysdig, I'm saying that it is from a ticketing company in Singapore, and let the audiences figure out. They know if you are from Singapore, you know which company I'm talking about, but I want to maintain my professional integrity. So I don't want to mention any names of company to the best of my abilities. Got it? So that's the first scenario. The second scenario is that when you have the information that you are going to teach and they are from other people. So this is something that you've got to really understand. You have to ask yourself, are you mentioning generic information, although you learn from other people? This information is generic, or it is a brand. It is a term that is branded and is licensed by other people. So I make a distinction here. Number one, if let's say you're talking about all the generic concepts, like for example, like my teacher Alex Mandossian has lots of all these conceptual ideas or what works for him, and I will always check the parameter from which I can share, because he allows me to share using my experience to share, of course. Then I have no problem of sharing what I learned from him, but I'm not sharing the concept directly that I've learned from him. I'm actually using my experience to share what I learned with you guys. So you see that the one powerful thing about sharing other people's information is that when you apply and create your own success, then all you need is you can give a credit to where you get the information, but most importantly, share how you apply such information to create your success. And of course, how you and your students, by using the same piece of information, create success. So it means that the information that you share actually works not just for you, but with your student as well. So sharing experience to me is always the most powerful thing, which is the reason why if you understand what I stand for, I always talk about result and action. Because when you have action, you have result. And when you have result, you can share your result. And there's no dispute, because at the end, results can be proven. Got it? If you are just sharing information, I learned from my Sifu this principle, and let me show you what I learned from him. But deep down, I'm not applying all this principle. I'm just talking about the theory. In my case, it's theory. Then you will find that I'm actually smoking or I'm actually bluffing, and you can feel it straight away. So therefore, one responsibility I have when I share anything I learned from my teacher or teachers is that such thing I have already implemented, I have created results. So now I have more confidence to say that this stuff works. For me, minimum, all right? So that's the thing. Now, there's also something that you need to know, that is what we call the copyright and trademark. Let's say, for example, some of you know that I'm actually a certified and licensed trainer with code breaker technology on this product called bank code. So for example, if I am mentioning bank code, I can, because I pay the license fee, and I have the right to mention that. But the question is that what if you are not a licensed trainer with code breaker technology, or you don't pay a license fee, so that you have no right to promote or use the brand? Therefore, if you are doing that, you are in breach of the intellectual property right. So this is something that I'm very passionate about, to help people understand that, especially when you're using the brand name of other people's product, even though it could be simply a product called Banco, or recently Blair Singer has a trademark called Sell Stop. I've seen one trainer from another country who actually uses Sell Stop on his video, and that's not cool. Why? Because Sell Stop is actually a licensed trademark. Okay, when you use a licensed trademark, you can, if you have paid the license fee. If you haven't paid the license fee, you can't use. So just understand this. Take note that trademark is not just a local law, it is worldwide, because when you register your trademark in one country, you can also register your trademark in other countries at the same time. For global branding, the creator of the program would want to trademark the brand as many countries as possible. So don't fall into this so-called trap by thinking that, oh yeah, because the brand is from United States, if I were to use it in Singapore, they can't catch me. Don't think like that because they are not stupid. They will seek global protection to the best ability they can. So trademark especially don't do that. Now the other common thing is on the copyright. Now this is something that you need to know about copyright because trademark is protecting the brand name, the trademark of the mark. Mark means the name, the symbol. It can be the service mark. So this is the subject matter. Whereas for copyright, it depends on where you come from. So remember at the beginning I said that copyright, I'm talking about the Commonwealth system. So in Commonwealth system, copyright is protecting the expression of information. Now this is different from the US law because US law, copyright protects the information. At least it's what I studied many years ago on copyright from US. But for Commonwealth, Singapore, Hong Kong, we protect the information in terms of the expression, not the content. So many times when you talk about copyright, it is very important, number one, you understand what it is protecting. It's protecting expression. So it's very important for you when you come up with any training program, you just don't talk about it and share with other people. Because the moment you share what you learn or what you're about to create with other people, and if that person put this down in the form of document, the expression will be protected. And you find that it's insane. Your idea, you come up with the idea, but how come the protection happens to be given to the other person? Because from a copyright perspective, you've got to understand that documenting your training program is the key. So all my training programs, for example, when I create my training programs on whatever subjects, I always have this thing called a documentation flow and the date of creation because it protects me as the author of the program. And the program is in the expression of slides, trainer's guide, learner's guide, all sorts of stuff. Because as long as it's not just verbal or just a thought, you reduce it in the form of written format, written instrument, the written instrument can be protected. So, okay, that's the key. Of course, there are further aspects about how many years copyright can give you the protection. I'm not going into that space. All I want you to do is number one to understand what copyright protects, which is the expression of your idea. So don't share your ideas anyhow, anywhere with anyone, unless you know the person will not do anything, which I can't guarantee. And two, do your best to actually put this in written form, so that when it's reduced into written form, that written form can be protected by copyright. Okay. And last thing, people actually thought about, how many of you have seen some slides or written document that underneath you see that C in the circle, copyright reserved, whatever. The answer is that how many of you realize that by putting this is actually helping you? The answer is no, because copyright is not registered. And even though you put there a C in the circle, it doesn't really help you at all. So I learned in law school that itself doesn't help you at all. All matters is actually your proof that you are the author of your creation. That's it. So that is just to tell the world that you are the author, but doesn't mean that by putting this you will get the protection of in full form. I always tell people that don't copy other people for the sake of copying without knowing whether it works or not. So this particular example is a very important piece. So last but not least, I want to talk about to what extent you want to actually use other people's references. I want you to understand that if, let's say, a sentence, like classic sentence, like how you do anything is how you do everything. You may have heard from Dan Lok, from T.F. Ecker, from Blair Singer, from as many teachers as possible. Because one thing about this is that this how you do anything is how you do everything doesn't come from all of them. It's actually from a root base, I can't remember the name, it's actually coming from another teacher. But the teachers that we know happens to use this phrase many times until now we forget who is the source. If you do comment below, help me remember who is the source of this statement. But what I'm saying is that if you see that a particular principle has been used by many teachers, okay, somehow, then likely you can use that. But I would like you to do one thing: credit your source. Credit to the person where you learn from. So when I say, well, how many of you remember like how you do anything is how you do everything? I always quote T. Harv Eker, because T. Harv Eker is the one from whom I learned this quote. So credit the source actually in that case is useful. But when you're using someone's program and teach someone else's program, you've got to make sure that you have the right to teach. If you don't have the right to teach and if the person finds out, you will get sued. And Americans are very, very furious to sue other people when it comes to violation of intellectual property rights. I'll just show you one story before I end. That was 3 years ago. I was given permission to model Alex's book called Alexisms. So he taught me how to create a book, and I called it Jackism. He even gave me the right to model his book cover. So until one fine day, Alex sent me an email and said, Jack, don't do anything now. Let me sort this out with the publisher. And you know what? The publisher saw the book cover of Jackism and wanted to send me a cease and desist letter. So Alex in the end went to talk to the publisher, and I was out. So you see that was a very good lesson. So I was reminded by Alex that next time when I model him something, although I'm fast, let him know first so that he won't get a surprise. And the reason why I'm sharing this lesson with you is that do not underestimate the power of litigation by US people, because they can sue anything, and you just want to avoid all this shit. All right? So thank you for watching, and love that you have learned something from it. So if you have any specific question, remind me. I'm not able to answer specific legal question because I'm no longer a lawyer in practice. All I'm saying is that you may ask. If there's a question I can answer, I will. And I hope that you are not being sued by other training providers, because this world, there are so many people who would love to copy other people's program, but you just have to be very clear with your parameters. Safe zone. All right? So if you do have other questions on speaking, training, and facilitation, let me know and comment below, and I'll be consider answering some of your questions in the form of future videos. All right? So thank you for watching. Jack Wong here, signing off. All good wishes.